Kai Rozga here again. Welcome back to the weekly wrap-up brought to you by Tech Law Decoded. In this week's episode, I'll cover the week's developments in tech, antitrust, and data protection. I'll start with a third-party complaint against Microsoft before the European Commission. I'll then preview next week's hearings by the U.S. House of Representatives in big tech. And then I'll finish off with an overview of the initial fallout from an important decision in Europe regarding Europe's privacy shield. Just a reminder, this is not legal advice, and anything I say here is my own view. So let's do it. Slack submitted a complaint to the European Commission alleging abuse of dominance violations by Microsoft. Slack is an app used by businesses to facilitate employee communication and collaboration. It includes chat rooms and messaging function, and more recently, video conferencing. And Microsoft has a similar product called Microsoft Teams, which is an app marketed to its enterprise customers that offers workplace communication and collaboration tools. It's a product that's seen a lot of growth in the COVID-19 environment. And so the complaint that Slack has submitted to the European Commission focuses on allegations that Microsoft illegally tied or bundled its Teams product with its Office suite, where Slack alleges Microsoft holds a dominant position. It alleges that there's been a forced installing of Teams as part of the suite, and also a blocking of its removal from the Office suite. So it looks like Slack is trying to draw some parallels to conduct that led to some large fines and remedies imposed on Microsoft by the European Commission earlier in the 2000s. Microsoft has responded that its success comes from, among other things, superior video conferencing, something that Slack has been slow to adopt, and that it doesn't see any competition concerns. We have not seen many antitrust complaints against Microsoft, so it's a notable development on that front. And because the company has largely flown under the radar when it comes to antitrust, at least since the big fines in the earlier 2000s. Moving on now, next week, 4 CEOs of big tech companies will be testifying before the U.S. House of Representatives Judiciary Committee. These are going to be the companies that are known as GAFA, so Google, Apple, Facebook, and Amazon. So what to expect? Probably some theatrics and grandstanding. The video conferencing is going to be the way that it's done. So that might take some of the sting out of the questioning, or maybe make it a slightly less circus-like environment than sometimes we're used to seeing in these hearings. It's also going to be a jam-packed day. So wouldn't expect there to be digging in on the issues. But quickly going through what might expect from the 4 companies. Google is feeling a lot of pressure right now. It's under massive investigations by the DOJ and state attorneys general's offices. So we should expect questioning on its ad business, in particular vertical integration of that business, and claims that the company has leveraged the dominance in certain parts of the ad business to benefit it in others. In particular by using access to large volumes of data. Also should expect questioning on the Android operating system and practices that are believed to have cemented the company's position as a dominant operating system on non-iOS phones. And also should expect some questioning on its general search engine, where again, allegations have included that dominance in that market have been leveraged to help Google services offered in other markets. Apple is a relative newcomer to the antitrust stage. Expect the focus of the questioning to be on its practices on the App Store, including whether it's advantaging its own apps in any way versus the third-party apps that are selling their services on the App Store. In particular, expect questions on the commissions being used by Apple, as well as restrictions that are believed to be imposed on its app developers about advertising other places where users can pay for the app outside of the App Store. Can't be a big tech party without Facebook being invited, though it's less clear what exactly the antitrust questions might be. The FTC's ongoing investigation is confidential, but it's believed to be focused on Facebook's prior acquisitions, like WhatsApp and Instagram, and the accumulation of data that's resulted from those deals. So perhaps the questioning might focus on Facebook's highly acquisitive strategy for growth. And finally, Amazon has faced a lot of public scrutiny lately following reports earlier this year about Amazon using data collected from third-party sellers on its marketplace, and then using that data to launch and promote its own private label products that Amazon sells on its own marketplace. So we should expect some questioning regarding data and how that might be used to advantage Amazon when it's acting as a seller, in addition to acting as a platform. Conspicuously absent is Microsoft, again, as mentioned earlier, a company that has generally avoided some of the antitrust scrutiny that the other big players have faced. Getting high-profile testimony from CEOs is not a surprising way for the House committee to finish off its nearly year-long investigation. And, likely something that's going to publicize the publication of its report stemming from that investigation, which is expected later to come out later this summer. Finally, companies and practitioners are trying to make sense of a new landscape for data privacy transfers between the US and Europe, following a major decision by the Europe's highest court, the European Court of Justice, in a case called Schrems. The ECJ invalidated a decision by the European Commission, which is the EU's executive arm, which had been the legal basis for what's called the EU-US Privacy Shield. The Shield is an agreement that previously, until now, had created a safe harbor for companies seeking to transfer data that was collected in Europe back to the US. For example, Facebook, if it was collecting Facebook user data in the EU and wanted to transfer that back to the US. The ECJ found that the Privacy Shield was inadequate because US laws are not sufficient to protect the individual rights of EU citizens whose data is collected and transferred to the US. But the court upheld the use of so-called standard contractual clauses, or SCCs, which are contracts between sending and receiving parties in a data transfer that set out certain data protections that are to be followed. However, parties have to ensure that the law of the destination third country provides for adequate data protections under EU law, so that imposes sort of an additional burden on parties relying on SCCs. So the immediate consequence is a major shakeup in tech, where US-based companies collect extensive data in Europe. Companies are now actively reassessing the legal basis for their data transfers and seeking to ensure that they don't violate the GDPR, which is the sweeping EU data protection law that comes with major fines if one violates them. And this may be a difficult task for smaller companies, especially when it comes to making judgments, for example, about the adequacy of data privacy laws in other countries. Long-term consequences are less clear at this point. Some questions out there about whether SCCs will stand up as adequate legal bases for specific transfers of data. And so we may see a political solution play out here as well. So that's it for this week. Antitrust, data protection, and tech, all wrapped up in 9 minutes here. For more on the latest developments in the worldwide efforts to regulate the digital revolution, check out techlawdecoded.com or follow me on Twitter @Kairazka. Until next week, have a good weekend, have a good week, and take care.